Good afternoon, everyone. Welcome to the Delaware Public Service Commission meeting of June 28th, 2016. Commissioner Conaway.
Yes, I'd like to take this opportunity to thank everybody on staff and with all of the utilities and in the audience, both here and on TV, for their prayers and concern for my husband. He had his surgery on Friday and did extremely well and will be coming home to Delaware tomorrow. So thank you all.
Congratulations. Mr. Howlett?
Chairman Winslow, Commissioners, I would like to just take a moment real quick and introduce to you a wonderful new employee that just started on board with us on Monday, Miss Elaine Cinque, who is seated way in the back of the room, is the newest member of our administrative team. She comes with a lot of accounting background and a lot of good credentials, and she does everything. So we're looking forward to having her do everything here at the Public Service Commission. Thank you.
Welcome, Ms. Cinque. Thank you, Mr. Howlett. The first matter on the agenda is to the reading of the meeting minutes of June 7th, both the public and executive session minutes. Are there any corrections, changes to the minutes as have been submitted? If not, could we have a motion, please, to approve those minutes?
I move that the minutes from June 7th, public session, be accepted as submitted.
I second.
Is there any discussion on the motion to approve the minutes of June 7th, both the executive session and public session? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. The first matter on the consent agenda, it's my understanding, and Mr. O'Brien will correct me if I misspeak, but it's my understanding that Chesapeake would like to have that deferred to another date, and that the applicant, for that matter, has no objection to that request. Therefore, that matter will be deferred until a later date, leaving us numbers 2, 3, and 4 on the consent agenda. Is any commissioner wish to have any of the items on the consent agenda taken off the consent agenda for more intense look?
I will move that we adopt. Oh, I'm sorry.
Mr. Chairman, just on consent agenda item 1, if I could suggest that we remove that item from the consent agenda and then that the commission make an affirmative vote to continue consideration to a future meeting on that item so that the commission's action today is not construed as a no action, which under the statute would deem the application approved. So I think we need to make that a little more formal than what you've suggested.
I have no problem with that. Is there a timeline on this one?
We just need to not take no action today. Use the double negative.
We're
So we
gonna
need to take an affirmative action to defer it today.
We're going to take action which is not no action.
So if we could just move that to the regular
deemed to be
agenda
no
and
action in
consider
the
it
future.
separately, if that's what I'd suggest.
Okay. Do the proponents of the motion have any objection to that friendly amendment from a non-commissioner? I would ask that be attributed to me, that change. I think it's a...
But I think we need to consider it as part of the regular agenda if we're removing it from the consent agenda.
No, I agree with what you're saying. So it would be taken off the consent agenda to be placed on the regular agenda.
And then we can go through this all again.
Okay. Okay.
Thank you.
Fair enough.
All right. You
Point of clarification. So should I recommend, as commissioner, that item 1 be removed from the consent agenda and move to the regular agenda?
Yes.
Yeah.
Second.
Any further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Thank you, Ms. Mira. Okay.
Mr. Commissioner,
Mr. Commissioner?
I'm sorry, Mr. Chairman. Item number 4 on the consent agenda, 150711. Just like to point out, on the order itself, we need to make a slight correction on the first whereas, line 2. The proper name of the company is actually Energy Services, LLC. And the LLC is missing from the order and I'd like to have that put in. So we have the actual proper name of the company for future reference.
I concur. Who made that motion? Is that Commissioner Gray again?
Which motion?
To correct.
To
Consent
correct? Now, I was going to start on the consent agenda, so.
Okay, well, why don't you make
All right, I'm going to move that we adopt the consent agenda items 2, 3, and amended number 4.
I second.
all those in favor signify by saying aye.
Aye.
Any opposed, any abstentions, the motion passes unanimously. It's going to be one of those days, it looks like.
Off to a slow start.
So, we're warming up, I hope. The next item is the regular agenda. And the first matter there is in the matter of the notice of potential violation of 26 Delaware Admin Code 8001 relating to the Coolidge Admirals Club LLC. Would the parties in that matter please come up to the table? Welcome, Mrs. Trombetti.
Yes.
Ms. Merrick?
Thank you, Mr. Chairman and Commissioners. You have before you in docket number 15-1463, proposed order number 8889. This is a result of the Commission staff's enforcement of the federal pipeline safety compliance program with respect to the entity Coolidge Admirals Club LLC, which is the operator of the Hunters Crossing Apartments, which are located in Newark, Delaware. This matter is a result of a standard inspection which was conducted by staff in 2015, which resulted in a written report issued July 9th, 2015, which noted some issues and failure to comply with the entity's operations and maintenance manual. These included the failure to conduct a leak survey of the distribution system, a failure to exercise key and critical sectionalizing valve of the distribution system within the required time period, failure to inspect and test for atmospheric corrosion within the required time period, and failure to monitor the cathodic protection system of underground piping within the required time period. In addition, there was a failure to review and update the operations and maintenance manual, which is required in an interval not exceeding 15 months, but at least once every calendar year. Each of these observations is a potential violation of the federal regulations that monitor pipeline safety. These were brought to the attention of Coolidge Admirals Club LLC with the issuance of a notice of potential violations on October 1st, 2015 by Commission staff. There was discussion back and forth about taking remedial actions. The company was compliant with those remedial actions, which resulted in an agreement to a consent agreement between staff and the company regarding the remediation, as well as the imposition of a total of $4,000 in civil penalties. The consent agreement was signed on August 26th of 2016. It's attached to this proposed order. It is staff's position that they have negotiated a compromise that's in the public interest, that there is not a need for a formal evidentiary hearing, and that this yields a reasonable result in dealing with the potential violations, imposing $4,000 in civil penalties, and then ensuring compliance going forward. So the order before you today would ask the Commission to approve the consent agreement which staff has reached with Coolidge Admirals Club LLC and assess the $4,000 in civil penalties. So staff would ask for the adoption of Order 8889, and our engineer, Jerry Platt, is available if there are any questions from the Commissioners.
Thank you, Ms. Mayrack. Ms. Trombetti, you're here on behalf of the owners. Do you wish to make any comment?
I'm here to answer any questions anyone may have in the matter.
Does anyone have any questions of Mrs. Trombetti?
Ms. Trombetti, how long does it take to conduct a leak survey of the system, the time frame to conduct a leak survey? Or Jerry, this might be a question for you.
Actually, I'll let Ms. Trombetti answer.
The actual testing itself,
Is
from
that
my
done-
understanding, is completed in a day or two. Yeah, it's quick.
And another question followed, how long, there was something about the key critical sectionalizing valve, and is that part of that whole testing as
Yes,
well?
it's all done together.
Okay. And you mentioned this in the order, there were repeat offenses, were they along the same line of not getting the inspection done in time?
Do you want to address that, Jerry?
Sure. Going back to 2013, we had written violations against Coolidge Admirals Club for, at that time, three things. Failing to exercise their critical valve, failure to check their cathodic protection system, and then, excuse me, and then not following their procedures. So a couple of the offenses this time, yes, were the same ones going back to 2013. And I might add that in 2014, it looks like nothing was done. We made the mistake, staff made the mistake in 2014 of inspecting them too early in the year so that the corrective actions they had taken in 2013 made them still in compliance. And then when we got to their inspection in 2015 is when we noticed they had not done anything since the corrective actions that we had required back in 2013.
I can offer an explanation if you...
If you'd like to, please.
At the time, I was responsible for, or assigned the property as a regional manager. My on-site community manager was responsible for dealing with anything related to the pipeline. And it was basically a misunderstanding and a miscommunication between the on-site manager, the vendor, Henkels and McCoy, and myself. I came into the property right at the end of the first violation and was assured that everything would be taken care of. Unfortunately, in January of 2014, the on-site community manager went out on sick leave for a serious illness, and she never returned to the job. So that was the breakdown in communications, where I was under the assumption that the vendor, Henkels and McCoy, was administering the proper testing and adhering to the timeline. And that was not the case. Since that time, obviously there's a new manager in place, and we have developed, or I personally have developed, a much more professional and a closer relationship with the vendor. That was part of the problem, that they were very unresponsive in the beginning, and we would wait weeks and weeks for responses from them. That is changed now. I have met all the on-site people. I am at the property, met the foreman. So we have a much better relationship, and we are going forward preparing to enter into an agreement with them that will make them the responsible party, of course, with our overseeing, to watch the timelines and perform the necessary tasks when they're due, to ensure this not happening again, basically.
Thank you, Mrs. Truman. Would someone care to make any comments about whether or not we should approve this settlement?
I move that the commission approve the order number 8889 as presented by the staff.
I'll second that motion.
Is there any further discussion on the motion to approve proposed order number 8889?
Yes, Mr. Chair, I have one minor edit on page 2. There's a redundant sentence. Delaware noted his findings in a written report dated July 9. Same statement in page 2. Minor edit.
The sentence.
Yeah, that line repeated on both pages.
Yeah.
No further.
May we have a motion or did we have a motion to approve? As amended.
As amended, yes.
Is there a second?
Second.
Is there any discussion on the motion as amended? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Are there any abstentions? The motion passes unanimously. Thank you, Ms. Trombetti.
Thank you.
Best wishes. You know the old expression, three strikes and you're out, right?
Right, exactly. It won't be the third strike, I can guarantee that. Thank you.
Number 2 is in the matter of the application of Tidewater Utilities Incorporated with respect to their DISC. Ms. Mayrack.
Thank you, Mr. Chairman and Commissioners. You have before you order number 8907, which concerns two dockets, docket number 14-0525 and docket number 15-1000. And this is the closure of Tidewater Utilities Incorporated DSIC filings, which are the distribution system improvement charges. And this, as the commissioners are familiar, is an opportunity for the company to come in January, on January 1st and then on July 1st to seek, to collect this DSIC for any eligible distribution system improvements which have been put into service between rate cases. And how the commission handled these previously was in both of these dockets, 14-0525 and 15-1000, was to approve on a temporary basis the DSIC rates to go into effect, subject to review and audit by commission staff. Which then, so you had a rate that went into effect on January 1st, 2015, and then again on July 1st, 2015. Now here we are at the end of June 2016. The staff has had the opportunity now to audit these charges and present its staff finding to the commission. So staff did audit these charges and has found no discrepancies. There was a small change to there was a reduction in the overcollection, which will be reconciled actually in the next DSIC, which will be opening in the next docket. So staff's recommendation is that the commission approve both of these DSIC rates as final now that the audit has been concluded. And Josh Bauman is available if there are any questions by the commissioners. Staff would ask that the commission adopt order number 8907.
Thank you, Ms. Mayrack. Ms. Higgins?
Thank you. We are in agreement with the form of order and want to thank staff for its audit, and we are in agreement with its findings. If you have any questions, I'd be happy to answer them.
Ms. Iori, any comments at all?
The public advocate was not involved in this document.
Anybody have, any of the commissioners have any questions of Ms. Mayrack or Ms. Higgins?
Move that we adopt order number 8907 as presented.
Seconded.
Is there any discussion on the motion to approve proposed order number 8907? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Are there any abstentions? The motion passes unanimously. Thank you, Ms. Mayrack and Ms. Higgins. You're going to be sitting there a while longer, though, right?
One more.
Number 3, in the matter of the application of Tidewater Utilities, for the approval of this semi-annual adjustment to the, I call it DISC, DSIC. In any case, Ms. Mayrack, would you explain this to us, please?
I will try. Thank you, Mr. Chairman and Commissioners. Now you have before you in docket number 16-0656, order number 8904. So what the Commission just approved was closing the D6 that were filed on January 1st, 2015 and July 1st, 2015. This is now the one that would open on July 1st, 2016. So previously the Commission, in docket number 15-1567, order number 8833, the commission had approved a DSIC rate of 1.06%, which again was subject to additional audit and review. Now this is the version that comes up on the semi-annual on July 1st, and this would be a change of the DSIC rate to 1.90%, which would result on average in an increase of $1.63 on a customer's bill per quarter. I will note, when the staff completed its review on the last two dockets, which you just approved, there was a slight adjustment, and the company did revise their application, which resulted in an increase of the DSIC from 1.89 to 1.90. And that is reflected in the order and the memo that you have before you now. And I do want to point out that the version of this memo and order that was originally in the commissioner packets and linked on the website was actually erroneous. It was to a prior version. So the version that you got this morning is the correct version. And I have copies available for if anyone else needs to review a copy, but I believe all the parties are aware that we've corrected that issue. So again, staff, this is just asking that the commission allow the DSIC rate of 1.90 to go into effect on July 1st, and it's on an interim basis subject to audit and final approval, which will likely come approximately 1 year from now for the commission's final approval. The staff would ask that the commission adopt this order, 8904, in the correct and current form as it is before you. And again, Josh is available if there are any questions.
Thank you very much. You think it's the same speech?
Well, she stole my thunder, so I had all of that. So I don't have anything else to add, but if you have questions, I'll be glad to answer them.
Thank you very much. Anybody have any questions of Ms. Mierak? Commissioner Gray?
Yes, Mr. Chair. So in this, in the one we just approved, there is in staff's memo an indication that there was an over collection of 3423, and it would be reconciled in PSC docket 160656, which is the one in front of us. Has that reconciliation occurred or taken place before this calculation in 160656?
The over collection that you're referring to is added into the revenue requirement collection that is part of 160656. I don't know if you have a copy of it.
So I just want to know if it's been taken into account before representing and proposing what's being asked for in this document.
Yeah. That over collection is part of the 1.90%.
Okay, thank you.
Okay. Move we adopt order number 8904 as presented.
It's the revised.
Yeah.
Just to clarify, it's the one that was in front of you this morning. I'm not asking for any revisions. It's just a switch of what was previously in your packets from last week.
Yeah, this is the one that I got this morning.
1.6.
Mr. Gray? No. Okay. Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Anybody in opposition or abstaining? Thank you.
Just who seconded the motion?
Number 4 is in the matter of the Commission's review of the necessity for cybersecurity guidelines or regulations. Mr. Willard?
Yes, Commissioners. Staff has prepared a petition for the Commission requesting that the Commission authorize it to conduct a review of whether cybersecurity guidelines or regulations are needed. In this day of constantly hearing about people being hacked, etc., our systems are not necessarily new all over the place, and they are subject, we fear, to being misused. And so we want to ensure this quality service, which the commission is obligated to do under the law. And they're subject to these vulnerabilities. So the commission, we would ask the commission to allow us to do some workshops, meet with other utilities, try to get together on whether or not we need some guidelines or regulations to provide cybersecurity. We're asking for the commission to approve that. Order number 8898 is in your packet, which would do so.
Thank you, Mr. Wilder. Is there anyone besides Ms. Scott from a public utility that desires to be heard on this matter? Ms. Scott.
Thank you, Chair Winslow. I'm here on behalf of Delmarva Power just to offer a couple comments. We obviously don't have any concerns with the opening of a docket, but cybersecurity is obviously a huge issue for my company. And something we spend a lot of time on, and it's also, by its very nature, a lot of what we do is extremely confidential. And when I see a docket that talks about having 2 public workshops to talk about this, I think at most you're going to get some very high-level conversation, but maybe not much beyond that. And I'm wondering whether it might be helpful to perhaps have a stakeholder working group where the utilities are represented in that regard to have some further discussion about this, and they could bring to the table their level of expertise around this issue. I can tell you specifically in terms of Delmarva now being part of Exelon, we have a lot of people that work in this area on a daily basis, and we would like to be obviously involved in the forming of whatever recommendations might come back to the Public Service Commission about how this moves forward. In addition to that, we are also, as part of Exelon, involved in working in some of the other states that now have put some things in place around cybersecurity. So I wanted to offer that as a role, perhaps, that we and the other utilities might be able to play in this process, considering the fact that a lot of what could potentially be discussed probably won't because of the confidential aspects of what we do actually every day.
Thank you, Ms. Scott. I think that all the commissioners and staff are well aware of the confidential nature of some of the information under this heading. Secondly, we're well aware of FOIA, and in fact, we don't want to capture a lot of material that would be discoverable possibly by people making requests under FOIA. I believe the document gives staff the flexibility to do what you stated, but Mr. Willard, am I right or wrong on that?
I think that's true, Your Honor. I don't know if Connie wants to say anything about that. But again, as was said, other states are doing this now. We really think we really need to get going on this, and I think we can work with the utilities in a way that protects their confidentiality and still provides information for us.
Maybe we could take the word public out and just say 2 workshops and leave it general.
Okay, the recommendation by Ms. McDowell is to take the word public out of public workshops and just make it a general phrase so that
we still have
workshops of any nature could be, well, all those details can be worked out afterwards. I don't think we have to worry about.
I mean, just as counsel of the commission, I would add there is the Freedom of Information Act, which has open meeting requirements.
Right.
I think there would probably be a way to have, I mean, as a government agency, there are no non-public workshops or non-public meetings. So if it was noticed as a public workshop, then there could also be noticed perhaps going into an executive session. The commission has regulations that allow for the filing of confidential materials, which would then not be subject to disclosure under FOIA. But I don't think we get around this by, from the outset, having a not public workshop in the form of order.
And I would agree with that myself.
Okay, it's just the language, as far as I'm concerned, is fine. I mean, we all are aware of the FOIA requirements. We're not going to run astray of them. On the other hand, we know that staff members can certainly sit down with members of industry and talk about issues. Doesn't have to be everything. Every conversation does not have to be a public workshop or a public meeting. So I just wanted to make sure that the industry is perfectly aware that we're aware of the sensitivity in these areas. Of course, naturally, you see that our council is going to make sure that we do get in accordance with FOIA. So that sort of sharpens the whole issue for all of us. But I do think that we need to take, obviously, the input from industry as well as we can in order to formulate what our needs are here in this area. Does anybody else have any comments to make?
Ms. Scott, I have a question for you. Was Exelon involved in any of these best practices, orders, or manuals with information when Maryland and New Jersey and D.C. and Pennsylvania put together these?
I know that they were involved, PICO was involved in what Pennsylvania did not too long ago. And so we do have some people from PICO that are very familiar with that. In New Jersey, Atlantic City Electric Company, which has been part of PHI for some time, was obviously involved in that process as well.
Mr. Howard.
Chairman Winslow, I would just like to point out that we are well aware of the FOIA requirements related to this, and we will have to be very careful because FOIA is very specific about what confidential information may and may not be considered confidential by the Commission. So I don't believe there is anything in FOIA that specifically addresses cybersecurity at this point in time. And so therefore, if we were to get into any confidential information with respect to that, it would probably be FOIA-able under the FOIA law. I'm not an attorney, and I'll reserve judgment on that, but I believe that there could be an issue associated with it, which means we will definitely stay away from confidential information with respect to this.
Mr. Chair, if I might, Ms. Scott, thank you. I'm listening to where is the balance, and I've been invited to a number of forums, either with the NARUC or with Pennsylvania's governor, who has assembled stakeholders, if you will, to discuss this topic. I'm wondering, do we have the appropriate legislative statutes to take the necessary actions that we should be taking in this arena, lest we're left behind? I mean, a chain is only as strong as its weakest link, and I think this is a very, very important topic and a very important issue. And where we need to draw boundaries around it, do we have the appropriate tools to do so? So I leave that as an open question for the people in the room, but it should not discourage the fact that we have an absolute need and requirement to address it.
I'm not prepared to answer that question, but I would point out that this body has previously heard arguments over FOIA involving confidential information from utilities. And we made a mistake, and we did not grant confidential status to a confidential document of a utility, and the Court of Chancery ruled that that was not correct. So I feel pretty confident that if there's something confidential in nature in the possession of a utility that they decide to share with us, marked under our rules as confidential and deemed to be confidential by the Commission, that it would probably be upheld. I think it's probably lawful, but a lot of devil in the details. So I think that what the executive director is saying makes a lot of sense, which is if we can accomplish our task without getting into the nitty-gritty and getting all kinds of confidential documents in our possession, we're better off for it. And I think also that what Commissioner Gray is saying about looking at the legislation and see if there's something we need to have changed makes some sense. And I'm sure that the people in the room here who have heard the comment will get back to us if they think there is something that needs to be made or changed. Or also Delmarva or Exelon could make suggestions about legislative changes. I mean, we're working this issue together. And I'd also say as a last comment that this is not coming up because of any real concern about what the utilities are doing with respect to cybersecurity. As a matter of fact, the person from PHI who is in charge of cybersecurity has been invited to speak at nationwide forums on this issue, and she's done it appears to be a fantastic job in that area. Exelon is just going to make it even stronger. And of course, as we well know, they keep the lights on in the nation's capital, so they got every reason and every need to be very, very vigilant on this issue. So this is really not a concern about the utilities' action in this area. It's rather sort of a supervisory and, in fact, a recognition that all of our neighbor states have done this, and when we don't have a similar platform, and we need to look at it and see if we want it.
And again, Commissioners, as we said, the law itself says we're to provide adequate services, and I think this is certainly part of that. Safe, adequate services.
Okay, do we have any more discussion?
Mr. Chair, I move that the commission adopt order number 8898 as submitted.
I'll second it.
Is there any discussion on the motion to approve proposed order number 8896? Hearing none, all those in favor signify by saying aye.
Aye.
8898.
8898.
98, excuse
Sorry,
me.
8898.
Anybody opposed? Any abstentions? The motion passes unanimously. Thank you all very much.
Do you want to do the deferred one?
I think you got it, Dan. We got this spot coming up a couple of years. Number 5 is in the matter of the application of Delmarva Power and Light with respect to the UFRC. Mr. Geddes.
Mr. Chairman, members of the commission, Mr. Howard has appointed me as the representative of staff to explain to you why, contrary to representations in your agenda, you do not have a staff memo in this particular matter or an order. Now, these two applications are very similar, but I'll address the first one, the gas application with regard to why that material is not before you. You do have, which we shared with the company, a one-page document, which I really don't think is relevant to the policy decision that is before you. There is a maxim that says, no good deed goes without consequences or punishment. And I guess my good deed was trying to present to you a consensual order, which I thought last week we could do. Unfortunately, I was wrong on that, and that there is an issue between the company and staff as to how the relocation facilities charge should be administered. Now, you've already heard in several dockets today already about the DISC, or DSIC, or however you want to pronounce it, but which applies to water companies under 26 Delaware Code, Section 314. And there's uniformity with how administratively the DSIC is processed. As mentioned, if a water company has certain types of capital investment between rate cases, it can apply for what I call a rider for relief in between rate cases. However, when the water company files a base rate case to increase its base rates, the practice is that the DSIC, in accordance with the statute and the regulations, goes to zero, and then the company can collect future amounts outside the test period, but cannot collect those monies that are within the test period. Now, I believe I'm correct that all water utilities follow that practice. The issue before you today involves the gas division of Delmarva and the electric division. So I'd like to supplement our one-page document with some references to the statute and previous decisions. And I should. So The issue, the policy issue that's in front of you is whether the treatment of the facilities charge as it applies to the gas and electric companies should be administratively processed in a different way from the DSIC. Now, what's in front of you is Section 314, and I've highlighted some provisions of it so that it's clear that the charge for water companies is not to include rate base that is included in general rate case. So, as I said before, when water companies file their rate cases, they zero that out. Now, as you know, Delmarva has filed a gas and electric case in the middle of May, and they filed their application for this particular charge, which is referred to as the Utilities Relocation Charge. I don't want to mess up the acronym, because if you do, you might make it a verb. But in any event, but they filed for it, and after the rate case. I withdraw that last comment. I'm not really good with anyway, so they filed for the relocation charge, and the issue is whether it should be zeroed out, consistent with the treatment of the DSIC for water companies. Now, if you look at the statute, 314 and 315, which applies to relocation charges, you can see that the language is very much the same. In A1C, on page 2 of your handout, you cannot include investment in rate base that is in the general rate case. Now, it is clear, and I believe the company will admit, that the test period for the rate cases is 12 months ending December 31st, 2015. So clearly the existing facilities charge includes some of that investment. And staff's position is you're entitled to, obviously, that portion that is outside the test period, in this case, January through April, which brings us back to these numbers. But you're not entitled to carry forward that amount of investment that is also reflected in your rate case. It's consistent with the statute. It's consistent with the application of DSIC. These two are very, very similar in their application. If you go to the bottom of the first page, section 314, you can see that DSIC can be used for relocation of existing facilities based on government actions. Clearly, the relocation charge that applies to gas and electric companies is also for government actions outside of the control of utility that they have to incur costs for. And that's why in between rate cases they're allowed to have this surcharge. But having filed for a rate case, the statute's pretty clear that it has to be zeroed out. If you look at the page 3 of the handout, you'll see that it says any electric or natural gas utility that files under subsection B of this section will be subject to the same statutory requirements of a public water utility seeking to implement or change a DSIC rate as found under 314B1. So it's clear the legislature meant that these should be treated in a similar manner. And it's also clear that if you allow the company to not zero out the relocation charge, you're going to have a double collection for those facilities that are in the test period. So for uniformity and for ease of administration, it's staff's position that this should be administered the same way, and that when a general rate case is filed, then the preceding relocation charge should be zeroed out. The company takes a different position, and I will only anticipate one argument, so I won't ask for an opportunity to comment further. I would imagine that the company, and Ms. Scott is going to argue, well, that's true at the time that the rates in this case are finally set. But that's not what the statute says. The statute says when you have a change in base rates, and they have asked for, and you have granted them, the right to increase rates by $2.5 million beginning July 16th, and a prior order prior commission meeting. Now, one could quibble about the size of whether that really means what it means, but it is a change in base rates. And the statute says, if you're changing base rates, you have to zero out this relocation charge. So it is really just the policy issue of whether this commission interprets the statute consistent with 314, or whether you think that the company's argument is persuasive. I think it will be hard to argue that there's very much difference between Section 314 of Title 26 and Section 315 of Title 26. And finally, on page 4, you have the regulations that have been passed by the Commission. The Administrative Code, Section 1009, and you'll see that in Section 2.5 and 2.6, we've lumped together the DSIC and the UFRC rate. And it clearly states there it should be reset to zero, and that the burden under 2.6, the burden of proof to establish that the rate is not collecting investment that's in the test period of a pending rate case is on the company. And I've looked at the company's application, and I'm not suggesting that it should be more than a couple of pages, but it clearly doesn't address that particular issue. So it's staff's position that this charge should be zeroed out, and that's the issue before you. Thank you for your time.
Ms. Scott.
Thank you, Chair Winslow and Commissioners. Pam Scott here on behalf of Delmarva Power. I also have with me Marlene Santa Cecilia, who is with Delmarva Power's Regulatory Division and works on the UFRC filings for Delmarva. Mr. Geddes is correct. I think the primary difference of opinion here has to do with when the rate would actually be zeroed out. The regulatory and statutory provisions provide that the UFRC rate does get reset to zero as of the effective date of new base rates that provide for the prospective recovery of the annual costs theretofore recovered under the UFRC rate. Pursuant to statute, specifically Title 26, Section 306, which is the provision in the code that talks about when rates go into effect, the interim rate is considered a portion of the new base rate. And our argument is that as only a portion of the new base rate, that is not what was intended when the language talks about resetting the rate to zero for the UFRC, because we are not fully collecting on what we filed for in connection with the rate. I think the other thing that the Commission should keep in mind here is that while the statutory and regulatory provisions for the UFRC and the DSIC or the DISC are largely similar, they are for very different purposes. The UFRC is only to collect for unreimbursed costs associated with moving utility facilities because of some government project. That's the only reason for which we can collect here. On the other hand, under the DSIC, in addition to being able to collect for those type of expenses, water companies can also collect in order to replace equipment that has outlasted its useful life, in order to replace equipment so that there are no dead ends created in the facility, the utility facilities themselves. It's a much broader category of what they actually can proceed and collect under the UFRC rate. And for those reasons, I think there is a distinction between what we can collect under the UFRC versus what can be collected under the DISC. In addition to that, the statutory preamble to the legislation for the UFRC essentially says that the purpose of it is to provide for expedited relief for the recovery of these capital expenses that we have made for which we have not been reimbursed. If we were to reset to zero at the time interim rates go into effect, we are not making that recovery, I argue. And this is different from the purpose of the DSIC legislation. The purpose there, as stated, is to reduce the frequency and cost of general rate case proceedings. So in my mind, very different purposes, but also as I read the provisions with respect to interim rates as set forth in Section 306 of the Delaware Code, and the provisions in the legislation about new base rates going into effect, I see a distinction there, and that's why we're making the argument we're making today.
Thank you, Ms. Scott. Ms. Iori?
Thank you, Chairman. So just a few things. The distinction I think that Delmarva makes for the expenses covered is, in our view, a distinction without a difference, because the statutory language is the same for both the UFRC and the DSIC. Likewise, we think the fact that they're having different purposes for each of them is also a distinction without a difference, again, because the statutory language is the same for both. The only thing I would add is that I was stats counsel when we drafted the regulations implementing the DSIC and the UFRC, and well, the water companies participated, Delmarva participated, Chesapeake participated, and I think it was clear that we were intending that the UFRC be interpreted in the same way as the DSIC was, which meant that it reset to zero when a general rate case got filed. So for those reasons, I would urge you to accept staff's interpretation and reject Delmarva's interpretation.
So you're saying that as of the date the base rate case is filed, which would be, I guess, in the statute it says as of the effective date of the new base rates. Seems to be a little bit of difference. I mean,
Well, they both are the same. The statutes both say the same thing, the DSIC and the UFRC. So if it's, when base rates go into effect for one, then it's when base rates go into effect for both. But that's not how it's been interpreted over the years. And the DSIC has been in existence for well over 10 years. So there's been a standing interpretation of that in that matter. And every water utility who has come in, and I think what we're also remembering here is that in the rate case, the time period covered by the DSIC has to be in the test period for the rate case. It is here. And most of the time when a water utility comes in, it's in there too. And if you look at every water utility application for an increase in base rates, they will all say this included how much of DSIC that was in, and the DSIC is reset to zero because they are including those improvements that that plant investment in their test period in their case.
but I guess what I'm hearing, I guess, is that not all of their improvements which were caused by governmental actions are incorporated into their base rate case so that they will receive recovery. That's why, are we talking about money here? We're talking about money?
And the time.
I think Mr. Gaddis explained that staff is not saying that the improvements that are outside of the test period should not be included in the UFRC.
The January.
That's accurate.
Okay.
They should be included in the UFRC. It's only those improvements that are also encompassed within the test period improvements that Delmarva is seeking recovery for in the base rate case.
Yes, sir.
Just a short rejoinder. I understand Ms. Scott's argument at 2.5, but obviously we disagree. But if you look at 2.6, it clearly states that you have to prove that you are not collecting in your base rate case investments that you're seeking recovery for in the UFRC. And they have not done that. This is a 2-page application here. And they have not affirmatively, at least in my opinion, made any case to establish that the rate that they're seeking to include in the new rate, for which we agree from January to April, is devoid of test period investment. They have not made that case. And you cannot, I would respectfully suggest, read 2.6 out of the regulation.
Commissioner Correa?
For your information, say for example, there are two scenarios. One is that on Route 13 in Newcastle, there's a big restaurant, and they want to increase the size of their parking lot, and they ask you to relocate the facilities which is in their way. You will do that, and you will send them a bill. Most 99%, I would say 100% private enterprises, they will approve the bill, they will send you the check, they are homebound, no problem. Same thing, if DelDOT has a project to make a right turn lane, and they would like you to relocate the facility. So you, same basis, you send them the bill. Now what will happen with the government, as it has happened in my case many, many times, that they will send the auditor. They will send the auditor, look at the books, interview us, people who design the rate, and they will ask all these questions that are you duplicating? Are you not removing the investments once it's moved into the test period and out, and then zero it out and move to the new one, new rates? And DelDOT auditor, I assure you 100% will not approve the difference and will reduce your bill by that amount. So this zeroing out and then moving to the new rate only, to me, makes sense. What do you think? Yeah.
Well, I agree that it makes sense if that plant is in the rates that are presently being billed the customer. And I guess the crux of my issue, and I think the company's issue, is when does that happen? Does it happen in 60 days for the 2.5 million rates, and is all that plant considered? Or does it happen in December when we put our subject to refund base rates in? So that's the company's argument. Is not that they should not go to zero. I agree. 2015 is in the test period, and the 2015 UFER plant should go to zero when we start collecting it in the base rates. But the 2.5 million may or may not have that in the base rates. And when we read that effective date of base rates going prospectively forward, we looked out to the 7-month rates that are subject to refund that more fully represent the base rates that we would be collecting in a base rate case. So I think I understand what they're saying, but I think our difference is really timing. Does it zero in July, on July 16th, or does it zero in December, on December 6th?
And the answer, Mr. Geddes, is, you want to say it a second time?
Is that DSIC has exactly the same language in it and has exactly the same mechanics, and that's the way it's been administered on that side, and this is obviously the first time this issue has come up, and I suggest to you that the DSIC precedent is the one you should follow here. That's what the statute's intended. Before we had these riders, the rate-making calculus was pretty simple. Filed a rate case, and obviously in the old days you didn't get $2.5 million. You didn't get anything until the rate case was concluded. Now you have the advent of getting some interim rate relief, and you also have the advent of having what I call a rider, which is you're getting a percentage of this investment back during the 3-year or 2-year rate effective period of your prior case. But once you file that case, that advantage, if you will, or that privilege is extinguished by having a rate case where this will be considered and ultimately decided as to whether that investment is reasonable. But to do it as a company suggests doing it, they're collecting twice.
Mr. Chair.
Yes, Commissioner Gray.
So, Mrs. Scott, has the utility demonstrated in the application that the eligible distribution system improvements or facility relocations were not included in the test period rate base?
Okay, I have to interrupt for a second, Commissioner Gray. Unfortunately, I've got something I've got to do at 2 o'clock. It involves the Electricity Committee and a resolution I'm sponsoring in Nashville on behalf of the Commission. And so we're going to take a 10-minute recess.